including exculpatory information. It was called by the Attorney General's office, quote, a charade. And let me be very clear here. Seeking truth, seeking fairness, and advocating on behalf of a former governor who was ambushed, treated unfairly, and not given any process is not a charade. It's the most important duty that I can do for the governor, and it's the most important duty any lawyer can do when they see wrong, when they see ignoring the rule of law, and when they see someone is being treated terribly unfairly and they're not given access to the evidence. So the Attorney General has ignored our requests to re-review the report, correct it, supplement it. She's not given us access, as we sit here today, to all the evidence. Still don't have all the evidence, okay? And by not doing this, what she has said to the world is, just trust me. This is what I say the evidence was. This is what I think you need to know. Well, based on the limited information we have in our review of the report, we can't. We can't just trust it. We got to see the evidence, and we've been asking for access to all the evidence, and I'm sitting here today, and I still don't have it. The other reasons, and this is very recent, why the Attorney General's office has to recuse, okay? The last 10 days have proved that the Attorney General's office can't be involved in these matters involving Governor Cuomo. Number one, on November 9th, the Attorney General, without consultation to witnesses, selectively released transcripts, 11 transcripts, okay? How did they choose which transcripts out of the 41 they were going to release on November 9th, okay? And what's going to be in the next wave? And she says she's going to release all 41 transcripts in the interest of full disclosure and transparency, but that's not true, because there were more than 170 interviews conducted. 179 people were interviewed, some of them more than once. Only 41 were transcribed. Notes and memos from all the informal interviews of the other 138 people were not provided, and the Attorney General has not committed to providing them to us. But now that she's gone and decided to selectively release transcripts on her timeline in a slow roll, perhaps week by week by week, and there's no reason for that, because the Attorney General has said that they've released the evidence to the Assembly. So what's so hard about getting it released to me? And there's no reason for that other than to inflict damage on a week by week or every other week basis, okay? And I want to talk about some of the transcripts that were released. There's transcripts for Brittany Camiso, there's transcript for Charlotte Bennett, and there's a transcript for Alyssa McGrath. Well, all three of those individuals also had informal interviews before they were put under oath. Why didn't the Attorney General release those interview memos? Because this is a selective disclosure, and it's only giving you part of the story. Members of Governor Cuomo's executive mansion staff, the people who work there and worked there with him every day, cooked, clean, dedicated, everyday servants to the public and to the highest elected official in the state. They would hear everything going on in the mansion. They were interviewed, but not under oath. Their interviews will reflect that they didn't see any inappropriate behavior by the governor. Why wasn't that included in the report, and why wasn't that transcribed and released to the public like everything else? Again, the choice by the Attorney General on November 9th to only release some transcripts shows that decisions are being made not for the right reasons, but for political ones. There's a second problem, the redactions in those transcripts. So the 11 transcripts that were released by the Attorney General on November 9th have a bunch of redactions in them. And as I have looked at the redactions and I see what's redacted from the governor's testimony, okay, it's not consistent or intellectually honest or principled, those redactions, when you look at redactions at the testimony of other people, okay? So there are 4 pages, more, that are completely redacted from the testimony of Lindsay Boylan. We think that those 4 pages, based on comments later in Ms. Boylan's testimony, deal with her talking about Howard Zemsky in a relationship with her former boss, who was head of the ESD. Ms. Boylan sent Mr. Zemsky a disparaging message that he found jarring and threatening, and it was after he got that message that he had a flip-flop in his recollection about a strip poker comment on a plane that Lindsay Boylan doesn't even remember him being on. Why are those 4 pages redacted in their entirety? Okay, you redact those. Were they talking about what that disparaging message was? Were they talking about why he found it disparaging? Were they talking about what their relationship may have been that could have caused him to flip-flop? That needs to be unredacted. Yet, at the same time, Trooper 1's testimony, and let me add on Trooper 1's testimony, Trooper 1 was given no notice by the Attorney General that the Attorney General's office was going to release her transcript. Why would you not discuss that with people before you did it and just drop them? But putting that to the side, they left in Trooper 1's testimony, hearsay and false and salacious information that they thought would embarrass the governor, even though it's not true, but they left it in. Why would you leave that in when it's irrelevant and it's not even in the report? And the reason is to inflict damage upon former Governor Cuomo. Then what happened is after those transcripts were released, we end up on Saturday night, okay, November 13th. The transcripts that the Attorney General had out, and you could see it on the Attorney General's website, 3 of those transcripts disappeared. They weren't on the site anymore, okay? And the transcripts were Ms. McGrath, Ms. Camiso, and I believe Ms. Boylan, okay? And when this was discovered, the Attorney General's Director of Communications did a tweet that said, well, everyone has tech issues. But that's not why the transcripts were taken offline. We did a comparison between the transcripts that were taken offline and what they were before, and there were alterations to the transcripts. There were alterations in the redactions, okay? Attorney General's office needs to come clean on that. Those redactions, okay, more redactions were added to some testimony. And then in other testimony, including people, that worked with the governor, names that were redacted were suddenly unredacted. Attorney General's office got to explain that. But more importantly, the manner in which those transcripts were released and the choice of redactions, which were not consistent across the board, certainly leads me to believe that it was the Attorney General's office doing the redactions, not the purportedly independent law firm that she chose. Why would the Attorney General's office be doing the redactions? The Attorney General must address this issue as to why they are making the redactions if they are, and I believe that they are, and what is their process for doing it. And why can't the Attorney General release to me immediately all the unredacted transcripts and the interview memos? I'll go over to the Attorney General's office tomorrow, sit in a room and review it. I don't know why she won't do that. I don't know why the office won't do that. It's inexplicable to me. The other is that the choice by the Attorney General to release the transcripts, she said it was in the interest of full transparency now that there was a criminal charge against the governor, and that's just not true. That doesn't pass muster. And the reason it doesn't pass muster is because while Sheriff Apple filed what has been a very much criticized complaint without notice to anybody, including Ms. Camiso, but what is the logic of dumping a bunch of transcripts out while not only there's the pending criminal complaint, But there's a pending investigation. The district attorney for Albany County has told the world and told the judge, hey, we were doing our own investigation. Sheriff Apple, he jumped the gun and didn't talk to us. We need time to complete our investigation. What is the logic for the chief legal officer of our state, knowing there is a pending investigation and a pending Sheriff Apple complaint, to dump witnesses' sworn statements out to the world so that those witnesses can now see what the other witnesses are saying? Ask any district attorney how they would feel. Ask any U.S. attorney how they would feel if the attorney general had done that to them in a pending case. It compromises everything. It compromises an ability to get a fair trial, if this goes to trial. It compromises what witnesses now may say and change their testimony. This wasn't done because it was the right thing. It was done because it was the political thing, and to exact maximum damage on the governor. I mean, I read the New York Post. They've had a salacious story every single day based on those transcripts. And I can't help but draw a conclusion that that's what the release was meant to do, and the slow roll of the release going forward, and that the redactions and the unredactions factor into those decisions. Last thing I want to say is we sent a letter to the Attorney General, and we have asked the Attorney General to open an investigation into the unlawful disclosure of grand jury information. There is a new executive law statute, Section 75, and it requires the Attorney General's office to investigate complaints of law enforcement misconduct. There is no question there was an unlawful disclosure of grand jury subpoenas, okay? And it was published in the New York Post on August 30th and on September 1st. It is a felony for a law enforcement officer to disclose grand jury information because it is supposed to be secret. It's supposed to protect people. It's supposed to protect witnesses. It's supposed to protect investigations that end up nowhere. It's a bedrock of the law enforcement principles of our country, and that was violated here. There has to be an investigation, and I don't understand why the Attorney General hasn't opened an investigation, hasn't criticized what happened, or even commented on the unorthodox manner in which Sheriff Apple chose to proceed. Given all of this, and given what is in my letter to the Attorney General today, the Attorney General's office must step away. They must step away from decisions regarding the report of the governor that has her name on the cover. They have to step away from their open investigation of the governor for alleged use of resources, or alleged misuse of state resources. And they have to step away because someone running for governor has every motivation to prolong that investigation to ensure that former Governor Cuomo isn't a political threat. There has been, and there's no secret, I read the press, there's widespread speculation that the governor may attempt a political comeback. I don't know what the answer to that is, but the very fact that there is speculation and people are talking about it, we have unnamed former advisors talking about it, means that it's in the head of anyone who's running for governor. And we know that the Attorney General is, and she needs to do the right thing by the public, by the governor, and by her office, and recuse because of the gubernatorial campaign. I want to speak briefly right now about the New York Assembly Judiciary Committee's investigation. As I understand it, today and tomorrow, members of the Assembly Judiciary Committee are going to be looking at a draft report that was prepared by their outside law firm. We have asked the Assembly for access to all the underlying evidence collected by the Attorney General to the extent they're going to address sexual harassment allegations. We haven't gotten access to all the evidence. We would also ask the Assembly for access to any of the evidence they've collected in their various investigations. We are also going to ask the Assembly for the opportunity to look at the draft report as well before it's made public and to comment on it. And the reason is we don't want to see a report end up the way the August 3rd, 2021 report ended up, with the omissions and errors, and the fact that we have not been given access to the evidence puts us in a position where we cannot respond adequately. And that's where we are. I mean, the Assembly Committee graciously gave us the invite to do a submission, and we did. We did the best we could, but we don't have the evidence, and that makes it a little bit hard. And we have asked the Attorney General for the evidence. We don't get it, and the Judiciary Committee hasn't given it to us. We'd asked as well to be able to go into a room, look at the evidence, and do a more fulsome submission. The last thing that we're going to ask the Assembly Judiciary Committee is that they not address in their report that they're going to issue any allegations that are also being addressed by pending investigations. And that would include U.S. Attorney's Office in Eastern District. They have an investigation now into reporting on COVID data. We believe that that investigation will be closed, that there was no wrongdoing. But any report by the Assembly on this, I think necessarily could prejudice that investigation. The same with respect to this, the Attorney General's criminal investigation on misuse of state resources. We believe her office should recuse itself and refer it to another local law enforcement official to handle going forward. But the extent there's an open investigation, we don't think the Judiciary Committee should be addressing those allegations. They don't have access to the same materials as those investigatory bodies, particularly grand jury information. But I'll say again what I said before, and this is in my letter to the committee today. We know that the Attorney General's report has omissions and errors. Other people have pointed that out. They can't take what she said in that report at face value, and the committee, which consists of a number of attorneys, they just have a duty to not take it at face value and to address the omissions and errors. We'd like to get full access to the evidence to make a submission on that. But again, we will say to the committee, you can't take the Attorney General's report at face value. The next is that to the extent that they're going to consider the reporting of COVID-19 data, there was an extensive submission made by the Executive Chamber to the U.S. Attorney's Office. We're going to ask the committee that whatever report they issue will include and attach that submission. In addition, there was a letter from the New York State Department of Health's outside counsel on June 20th of 2021 to the Attorney General regarding preferential COVID testing, and the conclusion that there was nothing improper about the testing that was done. And in particular, the preferential testing extended to members of the legislature, including members of the Assembly Judiciary Committee and staff members. It also extended to family members of other state officials. And if the committee is going to address it with respect to the governor and people around Governor Cuomo, they certainly need to address it with respect to themselves and other state officials. And finally, on the issue of misuse of state resources, there's been a lot of focus on Governor Cuomo's executive staff and senior staff working on his book. They did, and the governor understood they volunteered their time. Their timesheets reflect that they took time off. All of that must be included, but more importantly, to the extent that the Assembly wants to address that principle about state employees doing other work, then they have to address the principle and the practice of staff members. And this would include staff members for the governor. I'm sure it's happening now with Governor Hochul as well as with the Attorney General, of their employees volunteering to work on campaign-related activities. That happened during the day, in the evening, meetings during the day. Are they taking time off? And is that misuse of state resources? And I think they have to address it, and they're going to have to set a standard and take a mirror and take a hard look at themselves and the practice in the state. I want to end it here. One thing I do want to say as well on the redactions on the Attorney General's report is please take the time okay, and look through and ask yourselves why certain redactions were made and certain weren't. Because you can kind of tell from what you read before, certain paragraphs, after certain paragraphs, why some names get included and why some names not. There's not a consistency, and the Attorney General's office needs to answer that question, and the Attorney General's office should no longer have anything to do with redactions and the slow roll release of the transcripts. If you're going to release transcripts, then you got to release everything. That includes the 74,000 documents they collected and all the informal interviews. Thanks for listening. We will be releasing or sending out the letters I sent today. I hope that we will hear back and that the Attorney General will make a decision to recuse her office. And I'm ready for any questions. But thank you for listening. I know this was a bit longer than I thought.
Thank you, Ms. Glavin. If you would like to ask a question, please use the raise hand function at the bottom of your window. We will take a brief moment to compile the Q&A roster. Ms. Glavin, your next question comes from Jimmy Valkine from the Wall Street Journal. Please unmute your microphone.
Hello, Jimmy Valkine.
Hello, Rita. Can you hear me?
I can hear you. I have to tell you that you had a tweet recently about the Jimmy Valkine rule, that there's only 6 people in the state of New York. A lot of my friends pointed that out to me. That's a great quote.
Thank you very much.
Very funny.
There's some feedback. Thank you.
Yes.
My question is regarding the Attorney General's investigation into the alleged misuse of state resources.
Sure.
Has the governor spoken to the office regarding that matter? And I'm wondering if you have any sense of where the progress of that investigation is. Is it something that's wrapping up? Because you hit on that explicitly today, and I just want to know exactly why and where it is.
I do not want to talk, because it is a grand jury investigation, I do not want to talk about any specifics of the investigation. What I will tell you is I know that investigation is very much active, and I believe, as I have said throughout the last few minutes, that the Attorney General's office, given that she's running for governor, needs to be recused from that investigation, and it should be referred to local law enforcement. I can't say anything beyond that. I know the investigation is active.
All right, Ms. Glavin, your next question comes from Mike Gormley from Newsday. Please unmute your microphone.
Good afternoon. Attorney, was the governor offered the opportunity to speak to the Assembly Judiciary Committee, and did you decline? And could you talk about that? And then just as a follow-up to what you said earlier, are you saying that there's a difficulty of an attorney general who's running for governor to be involved in this case? Because, as you know, when Governor Cuomo was attorney general, he had investigated Governor Patterson at the same time.
Okay. All right. So 2 things on this. One, again, I'm not going to talk about specifics about what the Assembly has asked for and not asked for. We've made submissions to the Assembly, but I'm not going to get into it beyond that. On the issue you just raised about Governor Cuomo with respect to Governor Patterson, what I'm aware of is that the governor, there was an investigation of Governor Patterson, but the governor referred that to Chief Judge Judith Kaye. And I think in my last presentation, I showed what the cover page of her report was, and it did not have Attorney General Andrew Cuomo's name on it. It had Judith Kaye's name on it. So I think there's a difference here. But following along that, that's one of the reasons why when this investigation first was proposed, the governor said to the Attorney General, look, I'm running, and this election's in the next year. You're not telling us you're not going to run. And so that's why let's appoint a judge to do it. And I, in my personal view, the judge that was proposed, former federal judge Barbara Jones, she is universally regarded by prosecutors, defense lawyers alike, as having unimpeachable integrity and independence. She would have been the perfect person to do this investigation, but the Attorney General wanted to make the pick herself. So I do think there are differences. Next question.
Ms. Glavin, your next question comes from Louis Siderni of the New York Times. Please unmute your microphone, Louis.
Hi, Rita. Can you hear me?
I can, Louis. How are you today?
Good. Thanks. So
Sure.
Two questions. One, you're criticizing the logic of the Attorney General releasing the transcripts from the investigation, but at the same time, you've said for months that they should release all the evidence from the investigation. So how do you reconcile those two things? Are you saying only Cuomo, but not the public, should have access to the evidence, or that they should release everything at one time? And then the second question is, it seems like you don't want to get into specifics on this, but hypothetically, had Mr. Cuomo been asked by the Assembly for an interview, would your client have realistically sat down with an interview with the Assembly lawyers, in an investigation which you have said is no longer relevant because he is out of office?
Okay. Let me talk first about your first question. And it's a great question because a lot of people have been raising this. My requests to the Attorney General throughout have been release the transcripts and the evidence to us, meaning me. To just release it all to the public, okay, would subject people to the very reason why the New York State Police Investigators Union issued the statement that they issued, is that you're basically putting names of people out there, including people, who were irrelevant, and you're also putting out there hearsay and gossip. So what I had asked the Attorney General to do was to release all the evidence to us, okay? But there's a major point in time. There's a red line now, and that's why we have to question about why the Attorney General chose to release transcripts now. Given Sheriff Apple's unprecedented filing of a criminal charge against Governor October 28th, that changed the whole ballgame. And let me explain why. I wanted the transcripts, and I wanted all of the documents, and I wanted all the interview memos from day one when the report came out on August 3rd of 2021. I wanted them so that we could respond, the governor could respond, so we could do a submission, okay? And that's what I meant. Once the Attorney General, okay, became aware that Sheriff Apple had filed a criminal charge on October 28th without consultation with the DA's office, and that the District Attorney's Office for Albany County took the position this was without consultation to him, and the District Attorney of Albany County said, we have been doing our own investigation, we need time to complete it, please give us that time. The Attorney General of the state of New York had no business blasting out to the world witness statements that are directly relevant to a pending criminal case, that's the Sheriff Apple pending criminal case, and a pending criminal investigation. The whole game changed once the line got drawn. And that's why I, right now, am just stunned that the Attorney General chose to do this. And the best example, I mean, you guys know this, because New York Times, you guys cover the U.S. Attorney's Office in Southern District, which is where I'm from. And I can tell you, like, when Jim Comey, he was my first boss as U.S. Attorney, if he had an open criminal investigation and the Attorney General of the state of New York had also done an investigation and had 41 transcripts of witness statements and another 131 interview memos. If Jim Comey told the Attorney General, I have an ongoing case, and then the Attorney General went and blasted those transcripts such that all the witnesses knew what each other had said, he would be furious. And so that's the fine line I'm drawing here. This isn't about full transparency, and we know it's not about full transparency. because the Attorney General's not releasing everything. And the timing of her release is certainly politically motivated. But the second, issue on the release of the transcripts and why now then goes to the redactions that the Attorney General chose to do. The Attorney General redacted pages of Ms. Boylan's testimony. And the question is why and what's in there. We believe that the pages that were redacted dealt with Ms. Boylan and her motivations in sending the threatening message to Howard Zemsky and what her relationship was with Mr. Zemsky that, that caused her to send the message. That's material to the conclusions and the credibility determinations in the report. That should be unredacted. At the same time, what the Attorney General also redacted is that the governor had testimony about conversations between the Attorney General's Chief of Staff, Ibrahim Khan, and Lindsey Boylan's campaign consultant, Trip Yang, who happened to have been the Attorney General's campaign consultant when she ran for Attorney General. They were having conversations when Lindsey Boylan was making these allegations. They were talking about what Miss Boylan was telling Trip Yang, and he was reporting that back to the AG's Chief of Staff. The AG, her office redacted the names of her Chief of Staff and Trip Yang. Why are those names redacted? And other names of executive staff members not redacted. So it's the release now, while you now have a pending case and there's a pending investigation, and then the choice of redactions, which, I look at them and they're not intellectually honest. And I think the redactions, there were motivations in it to cause less damage to some people and more damage to other people. With respect to the assembly and your question about hypotheticals, I am sorry, I don't answer hypotheticals. That's something I learned my first year in law school. Next question.
Ms. Glavin, your next question comes from Dan Clark from New York Now. Dan Clark, can you please unmute your microphone?
Hey, Rita, can you hear me?
I can, thank you. Nice to meet you, Dan.
Nice to meet you too. So we've been hearing from you for a few months, and I guess what a lot of us are wondering is, what is the end game to all of this? Are you preparing some kind of legal action against somebody using all of this evidence from the AG's report that you want? And who would that be targeted at? Or is this more of just like a kind of campaign to improve the former governor's public image?
There's two reasons why I have been doing this, and I'll continue to do it. This is about truth. The former governor was ambushed on August 3rd by a report that has so many omissions and errors. I feel it's as though it's almost built on a house of cards. It's not right. He wants me to fight for the truth, and that's what I do. And fairness. He was wronged by this. And if I were him, and it doesn't matter if I were the former governor of the state of New York or I'm just Rita Glavin, I would want a lawyer doing this for me. If I did not do many of the things that have been alleged, and I know that a report was issued about me that was wrong and one-sided. Isn't that what everybody would want to do? So that's the first reason. I'm doing it because it's the right thing. And he believes it's the right thing. The second reason, when you ask him about legal action, let me put it this way. I think all options are on the table here. This may result in some type of us pursuing some type of legal action. I can't say that that's definitive, but as the weeks go on, and, I've been watching the governor. I was aghast at the August 3rd press conference. I really was, because I haven't seen a law enforcement officer do what happened at that press conference. I was aghast at Sheriff Apple's August 7th press conference, where in the same breath that he says he's just starting and in the infant stages of an investigation, the sheriff then says, we have a victim. We're going to do everything we can to help her. We're confident she's a victim. I couldn't believe it. That's not professional. And so I am speaking up because I see drip, drip, drip every week. And I see things that I know are wrong things that are politically motivated. And I think an attorney general's office or an attorney general who's making decisions that are in the best interest of a job she desperately wants versus what's the right thing that I see law enforcement professionals do every day. So I hope I answered your question. I will take one more, and then I'm going to get back to work.
Ms. Glavin, your next question comes from Bill Mahoney from Politico. Bill, can you please unmute your microphone?
Hi, Rita. Thank you for taking the question. Just wanted to, the only charge that's been brought against the former governor so far has been the misdemeanor, but we've heard a lot of references to this grand jury involving Craig Apple. Does that mean that there is a felony under consideration? Is there still a felony from the sheriff's office that he's facing? Because the grand jury wouldn't have dealt with just this misdemeanor charge, correct?
You're actually wrong on this. Prosecutors can use grand juries to investigate misdemeanors. So they can serve grand jury subpoenas. And it's quite clear that based on the reporting of the New York Post from August 30th, and then again 2 days later, they talked about the subpoenas that were issued. And it is perfectly proper for a prosecutor to use a grand jury, even though they only end up charging a misdemeanor. Okay. Everybody, thank you for listening, and stay tuned. Bye.
Recording stopped.